Hi everyone, and welcome to this special edition of the Clarion Costs podcast. My name is Andrew McAulay. I'm a partner and the head of the cost team at Clarion, and I'm joined on this podcast by Matthew Rose, who's a solicitor and an associate in the cost team at Clarion. So we wanted to put this podcast together following a recent case of Barking, Havering and Redbridge University Hospitals NHS Trust versus AKC, who is a protected party represented by the litigation friend MCK. Now, it's a case which made its way to the High Court. Hearing was back towards the end of September, and we've recently had the judgment handed down. Oh, sorry, the hearing date was back in July, with judgment handed down towards the end of September. Now the case has some really important points in it regarding certification of a bill of costs, but we're also going to touch on certification of the statement of costs, which I believe it touches on the judgment, and information which needs to be provided in a bill of costs. So some really practical points in the judgment, which will be important for all litigators. But in essence, in the case, there's it went to appeal, and the three strands of the appeal were: was the bill properly certified because the signatory was not identifiable? And 2 and 3, was the bill correct in nature in terms of the name and status that it provided in relation to fee earners? And that point straddled both the old style paper bill and the new style electronic bill. But what the judgment does is it goes a little bit further than those 3 points and starts to give some practical guidance about who can sign, who can't sign, and what really should properly be included in those kind of documents. So Matthew is an expert on this area, because whilst this judgment came out towards the end of September, he had the foresight and knowledge to actually do a blog on the 9th of September on the point. So clearly he's got a crystal ball and he knows what's going to happen. So I thought I'd pull him into this podcast, and he can give us some practical advice, having read the judgment and following his blog on the 9th of September. So what do you think to the case, Matthew?
Well, I think it's very useful. And I mean, it wasn't quite a case of having a crystal ball. This is a question that I get asked so much. I'd rather got to the point where I just thought, you know what, if I just write the answer down in something, I can refer people to it when the question's asked. But it's something that frankly isn't clear from the rules, and it's not been clear for a long time. The way that the certificate to the bill of costs is drawn, it's actually it's kind of a holdover from the old rules of court, the RSC rules. So we're talking pre-CPR. So I think it's very useful to actually get this guidance. There are sort of there's 2 big areas. There's how you draw a bill and what information needs to go in the bill, and then there's how to certify that bill and who can certify that bill. So in terms of what information needs to go in to the bill of costs in relation to fee earners, who's actually doing the work, I think it's useful to just distill the judgment down. I think it can be distilled quite a lot because it is quite a long judgment. But essentially what the judge is saying is, if you are asking me to assess the bill, the party that's asking me to assess their costs needs to provide sufficient information so that I can identify, number 1, who's done the work, and therefore how experienced they are, and 2, in relation to individual items, who's done the individual bits of work. It's not sufficient for you to just say grade A fee earner or solicitor, and then just within the bill just have a list of grade A did these individual items. So what the judge said was, first of all, you need to be providing sufficient information as to who's done the work. And so my advice to anybody who's drafting a bill would be to ensure that when you're putting the details in at the start of the bill, the details of the fee earner or the file handler or who's done the work, you usually want either, usually a name, so it's going to be the name of the person who actually did the work, together with either grade A, grade B, grade C as a description, because of course, a grade A solicitor is defined within is defined within the court rules. Grade A solicitor is anybody with over eight years experience. So simply putting Matthew Rose, grade B, that would be sufficient to identify who'd done the work and what their status was. Alternatively, and sometimes it's better, particularly if you've got people with a lot of experience, 20, 30 years, is actually put the qualification date. That's the method that I prefer, and to put the person's qualification date either as a Silex or as a solicitor, or indeed as a cost lawyer or anything else. Even when you've got experienced paralegals, 20 years experience, this is when they first started. Putting the experience is always going to be useful to bolster that claim and to give the judge enough information. So that's the first point.
And just to jump in there, Matt, if it's all right, just to summarise then. So got to list the fee earner individually, no bandings. So it's, you can't be putting grade A, grade B, grade C, grade D, and banding
not without anything else. Just putting grade A solicitor isn't sufficient. You need a bit more.
Yeah, so you need to make sure it's got that individual element to it. So individual's name, and you can put their banding or state level experience, or you might want to do both.
Yeah,
but you need to do one of either the banding or the qualification date.
Absolutely. So the banding or the qualification dates, giving them the details to know how experienced they are and what the relevant guideline is, and then the name. I mean, I suppose you could put solicitor 1, solicitor 2 if you didn't want to put names, but frankly, I don't see why you would want to sort of hide who'd done the work. If you're putting the details of what status they are and what status they're claiming, you rather need to provide that person's details. If you're claiming somebody's a grade C or a grade B, you need to provide the details of who they actually are so that the other side and the court can either dispute it or agree with you. So that's really the first point. And then the second point was in relation to when you're drafting the bill, you put the description, so you put the date, 1st of June 2021, the description of the time done letter to opponent. And then there's a column in the electronic bill for who's done the work. And in this case, what they've done is they just put the grade. So it was A, B, C, or D. That I do have some sympathy with the author of the bill, in the sense that the way that the electronic bill's set up, it does sort of imply that you're supposed to put the grade of fee earner in that column. So it does require you to do a bit of tinkering with the bill. But what the judge in this case said was, if I've just got the date, the description, and the grade of the person who did the work, I have no way of knowing who's done that work. If you've got 3 or 4 or 5 grade A solicitors, say I've got 5 grade A's working on this case, I don't know whether each of them's done 20% of the work, whether one of them's done 95% of the work and the other ones have just sort of helped out when he's been on leave, or when they've not been available for whatever reason, or they've got some area of expertise that's useful. So there's no way of me knowing whether or not there's been duplication. And that, therefore, when you're drafting the bill, you need to, in relation to every single item, be identifying who has done the work. Now, when I draft bills, I put the initials of the fee earner. So I'll have Matthew Rose, and then at the start of the bill, it'll say Matthew Rose, brackets, MR. And then every time MR appears in the bill, that's been done by me. And that's just how I do it, the initials of the fee earner. You can come up with your own system as long as you can identify each individual item who specifically did that work. That's really what that judgment was saying. That needs to be in there.
Yeah, but a really, really important practical point there for anybody who is drafting an e-bill, or actually if you certify an e-bill, make sure that each individual who's worked on the matter can be easily identifiable. And I suppose the key message is banding people together. To be honest with you, we've never done that. We've never thought it was a good idea. This case confirms now, don't band 4 or 5 people together into one category. Make sure you individually set them out. And Matthew's point there about initials is a great practical tip.
Yeah, I think the real point with all of this is, I think, rightly or wrongly, I think judges take the view that where things are grouped together, there's an element to which, well, hang on a minute, why are you providing less information? there's a growing sense, I think, and I think the judiciary are becoming more and more alive to it, which is if you're trying to provide less information, why? Are you trying to hide something? And frankly, if you've got nothing to hide, if your bill and your time is sound, there's absolutely no reason to almost put a barrier in your way where it's going to cause the opponent to be suspicious. It's going to cause the judge to be suspicious. It's an easy win for them because it gives them something to attack. So it doesn't make sense. And of course, I fully expect that anybody watching this video is going to have nothing to hide. There's no reason to bury the time. You can always justify it.
And of course, just looking back all those years in Lord Justice Jackson's reports, what led to LASPO in 2013, he was highly critical of the old style bill of costs, said actually it was easy to hide entries in there, hide maybe week time. The whole logic behind the e-bill is to make sure it's transparent. You can drill down into the finest amount of detail, and just gives that true transparency, which is what should happen in cost assessment. So really useful there, Matt, in terms of the information, what needs to go into bills of costs, and you've explained about the point about e-bills. Just moving on to certification. So could you just quickly touch on certification of bills, and then we'll look at certification of statements of cost for summary assessment?
Yeah, absolutely. So the judgment, there is a lot of confusion, as I said at the start, about who can actually sign a statement of cost, and there has been for a long time. This judgment is very useful because it does clarify it. So the key takeaway point from the judgment is it has to be a solicitor. And I agree with that. I think it does have to be a solicitor. There are arguments.
In terms of bills, sorry. In terms of bills,
yeah. In terms of a bill, it has to be a solicitor. There's an argument whether or not it should actually be a partner. I did a blog on this, as Andrew said at the start of September the 9th. If you search for who can sign a bill of costs with a question mark in Google, it'll be up at the moment, 5th of October. It is one of the top results, so you can go and search for that and read through all the reasoning. But essentially what it boils down to is the rules. The court found you cannot alter the certificate on the bill. So the certificate to the bill of costs is a mandatory requirement of any bill. It has to include a certificate, and the court found you cannot modify that certificate, and that certificate refers to a partner. Now what the court said was, in accordance with the authorities with Bailey against IBC vehicles, it has to be essentially an officer of the court, which would mean a solicitor. So the judgment in Barking, Havering and Redbridge widens it slightly from the scope of the solicitor and says it has to be a solicitor. There's an argument to say it should be a partner. Personally, I think a solicitor, absolutely fine. But certainly you don't want paralegals. Silex, unfortunately, who of course have to go through a certification process of their own. Silex wouldn't be able to sign a bill. Perhaps that's something that needs to be addressed in future by the rules committee, but at the moment it seems that Silex wouldn't be able to sign a bill.
Yeah, and ultimately the judgment is effectively trapped by what the rules say. And I think there, Matt, there's 2 points there what spring to mind. If you've got someone who's a Silex and maybe 20 years qualified, and they ran that piece of litigation, you still need to have a solicitor sign the bill, but you would expect the rules committee to tidy that up, because that would be seem to me very daft to have the person who led the case and understands it not having the ability to sign it and having to ask someone who doesn't know as much as them to have to sign it.
Yeah, and another point to be very alive to is, and again, it's a tension with the certificate. The judge made the point that with ABS structures now, a director or partner in a law firm is not necessarily a solicitor. In accordance with this judgment, even if you are a director or a partner, if you are a non-solicitor, you cannot sign the bill. Of course, there will always be directors and partners who are solicitors, because it's part of the ABS rules that there have to be qualified solicitors as partners in any solicitor's firm. But that is important to note, that If it's a partner, it also has to be a solicitor. If you're a non-solicitor but a partner, you can't sign the bill. But like you say, I think there are elements to which that does need tidying up and addressing. And frankly, this whole issue could have been avoided if the rules were clearer and they updated the precedents and the rules. That's something that's going to need to happen. At the moment, it's a solicitor's got to sign the bill. In terms of statements of costs, was there anything you wanted to ask?
No, I think I just wanted to show everyone, obviously, this message where it's a safe message. We don't want people to get into defective service arguments. So whilst we probably could sit back and think about some creative arguments as to why maybe a Silex should sign, we'd rather actually just take a more safer approach. So get solicitor to sign bill, don't have any defective service issues, and hopefully the rules get tidied up later on down the line.
Absolutely. And just finally on statements of costs, because this isn't directly addressed in the judgment, but is dealt with in the blog that I did, and I think it's useful to mention it here as well, is that a statement of costs can be signed, and the rules actually specify that a statement of costs can be signed by the party's legal representative. And it actually says that on the statement of costs, the legal representative. Actually, I think the statement of costs refers to a partner as well, but the rules certainly say it needs to be certified by a legal representative. In theory, that would mean any employee of a solicitor can sign. That would include the office junior, the secretary, a trainee. Whilst that might be the technical position, I think that you almost always want somebody qualified. So you probably want a solicitor. I think Silex will be able to sign, and cost lawyers will be able to sign a statement of costs as well. But for safety's sake, following on from the judgment of Barking, Havering and Redbridge, it might be better to, as a policy, always have a solicitor sign, unless you are in a situation where it's got to go out, there's no solicitor available, it's got to be signed by Silex or cost lawyer or whoever else. Then in those circumstances, perhaps it would be something you would do. But I think for safety's sake, until this is clarified, it might be better to err on the side of caution and get a solicitor to sign. Yeah,
so just again to summarise, if you want to be extra cautious, statements signed by solicitors, but actually there's even stronger arguments to say actually more people can sign. Just to touch on the cost lawyer point signing, actually, if you read how you read the rules, they could sign, like you just said. I think actually though, cost lawyers, if you work in-house, should just be quite wary about signing the statement of costs, because whilst they might have produced it and they've looked at the retainer and they can understand things maybe a bit quicker in terms of costs than somebody else in the firm, they've not actually done any of the substantive work. They're picking us up at the back end. They've not lived and breathed it, not spoke to the client. They didn't do any of the substantive work. And I think therefore it has to be at least the Silex or the solicitor who's had some running of the file and day-to-day understanding of the substantive matter.
I can see the logic with that. The only counter argument I would have to that would be that you could have a claim that was run entirely by a Silex and they can't sign the statement. So they might have to come to me. I'm a qualified solicitor. They might come to me and say, Matt, can you just sign this statement? Well, it all looks right. I've had a look on the cost management system, on the cost system, on the accounts system, on the time recording. All looks right. Yeah, I'm certifying that that's not been exceeded. So I think there's the counter argument, which is that you could be in the reverse position, and it's a bit of an artifact and a holdover from older times. I do think it needs tidying up, but I agree that in general, people shouldn't be signing statements of costs if they don't have to. At the moment, it says solicitor. They're ultimately the ones who's putting the name to it. Just on that point, it's a final point, very, very quickly. In Barking, Havering and Redbridge, the signature of the bill, it was just a signature. There was no name, and the receiving party said, "We're not telling you to sign the bill." The judge said that was ridiculous. They said there's no requirement for you to provide the name on the certificate, but if the other side asks, you should be telling them who signed it. Yes. It's a minor point, but again, it's to make sure that the person, effectively, so the court and the other side can identify and satisfy themselves the person who signed that bill is entitled to sign it. So That's just a minor point at the end, but yeah, if they ask, tell.
That's an important point, Matt. And actually, you would think in the era now of more electronic work and digital work and electronic signatures and so on, that should avoid any handwritten annotations to a bill that people can't read and so on. So you think in due course, points like that should never happen again. But ultimately, to kind of finish off, subject to any final thoughts from Matt, if you've got a certified bill of costs, just make sure that the fee earners are individually identified, grades or level of experience is highlighted, and it's a solicitor who's signing it. If it's a statement of costs, up to you really how you approach it. We think we know the rules are more relaxed and it can be legal representative. If you wanted to be ultra cautious, make sure a solicitor signs. Have a read of Matt's blog on the Clarion Cost blog, www.clarionlegalcost.com, 9th of September. That gives some information. And if you're not sure anything, give us a buzz. But we really want to push this podcast out there because we think there could be some defective service issues, and we'd hate people to be serving and then having to do it again. So hopefully you found it useful. And subject to any final thoughts from Matthew.
The only thing that I'd say is obviously this affects bills that are in circulation now. If you served a bill, if you've got a bill going towards a hearing, particularly if the other side have raised it, they may be looking at your bill again. So look at your bills, any bills you've got ongoing, look at them, make sure that they do comply with this judgment. If you're in any doubt, feel free to give us a call. We can always have a quick look over and just check for you. But it's easier to amend now than it is to get to a hearing and find that the judge is sending you away to amend and ordering costs of the day. So just for safety's sake, just check through any bills you've got floating around that are in the system. And if you're unsure, give us a call.
Brilliant, Matt. Well, thanks for that. And yeah, if anyone's got any questions, please feel to give us a buzz or drop us an email. And thank you for watching.